Okay, my name is Jordan Kowalski. This is week 4 for Law 301, and we'll be discussing chapters 7, 8, 9, and 10, right? So, over these past few chapters, we basically moved from understanding what a legal syllogism is to actually building a full, complete legal argument. Basically, taking the laws and facts and transforming them into something a court is required to accept. Okay, so, chapter 7, the legal. Whatever, who cares? The minor premise, right? The factual side of a syllogism. If the major premise is stating the law, the minor premise is applying that law to the specific facts of a case. However, facts alone are not persuasive unless they are grounded, which leads us into what are called factual assertions, right? Basically, factual assertions are what they sound like. It is you asserting a fact to a court with the idea that it's going to be supported by evidence. That could be your testimony, your documents, your discovery materials, yada, yada, yada. A court does not accept conclusions. It accepts grounded facts. We just kind of mentioned that. So how do we go about actually that process of grounding those facts, right? Well, there are two different fact groups, right? They're what were called brute facts, and I can't speak. Brute facts and compound facts, right? Brute facts are observable physical facts. They are just like the brake pedal hit the floor, an actual fact that usually can't be disputed in court, while compound facts are kind of that extra step of inference, right? Like someone was negligent or the plaintiff did something unfairly, right? And the more we break down these compound facts into brute facts, which is kind of what you want to do, the stronger and more persuasive our argument becomes overall, because you want to make the judge's job as easy as possible because he's lazy, right? Basically, the only other thing from chapter 7 is that we elaborate on the key legal terms, like your words like your offer, assumption, risk. Those words by themselves don't really mean anything unless we define them using the proper authorities, because without the proper authorities, it kind of becomes conclusory. So you kind of want to ask the questions why all the time to basically keep grounding your reasoning until there are no unsupported gaps left. Okay, that brings us into chapter 8. Chapter 8 is basically the method of step-by-step process of doing just that. Basically, the blueprint for constructing a complete legal argument in this syllogism form. So, start with identifying your client's position and the relevant legal principles. Research, extract the controlling test, the proper controlling test, whatever one works for your case. Convert your position into syllogism format. Ground your major premise in the controlling authority, right? And your minor premise in the evidence. So ground them both respectively. If you can't ground something directly, break it down to further smaller syllogisms, that step-by-step thing we learned in class. Well, when we go to class, until everything is supported, right? Key takeaway is that every persuasive argument is recursive, that magical word. I'm not going to tell you what it means. I know what it means, but you don't. Look it up. If something is weak, don't ignore it. Just build another syllogism to support it, right? Which leads us into chapters 9 and 10. This is basically showing this process in action with an example. This is going to be really annoying to explain because my notes are all over the place with this, but here we go. So, defendant opposes plaintiff's motion to amend a complaint years after filing, 2 years after discovery closed. Instead of arguing, we apply the structured method because we don't want to argue with emotion, we want to argue with fact. Very exciting stuff. So, identify the target, the motion to amend, right? State our conclusion immediately. The motion should be denied. We don't bury the lead. And then, okay, so we set out for the law, right? There is a law that mentions that amendment should be freely given when justice is required. But since that language is broad, you want to turn the case law to clarify it, right? So the Supreme Court identifies circumstances where the amendment may be denied. First Circuit in Manzoli provides a concrete test. A delayed amendment should be denied when there is no valid excuse for a delay. Yada, yada, yada. So basically, you apply your tests, you apply your evidence. That's basically what Chapter 9 is about. It's just kind of what we learned about in Chapter 8 and 7, just in action. It's very boring. Chapter 10 is just basically showing us how the entire argument is structured and troubleshooted, right? Just a clear introductory paragraph we got, which stated what we're arguing. Then we walk through the law, the test, the application, bolster our reasoning with precedent and what else works. Even if it's not binding, we close. If it's not binding, then you close or state your conclusion. Just examples from 9 and 10, right? Ultimately, these just teach us that legal reasoning is just a disciplined structure. Persuasion in law doesn't come from volume or emotion, but actual fact, right? So by the end of chapter 10, we are no longer just identifying syllogisms, we are constructing complete legal arguments that the court must accept, like I said at the beginning, right? And that is what it means to think like a lawyer. Woo!